on whether Louisiana's newly drawn congressional map is unconstitutional. This is live coverage on C-SPAN.
But we'd rather not be caught between two parties with diametrically opposed visions of what our congressional map should look like. But this has become life as usual for the states under this court's voting cases. And our fundamental question today is, how do we get out of this predicament? Now, I think there are at least three ways to do that. First, you should reverse on standing grounds, because the only theory of harm in the red brief is that our black representative of District 6 will play into racial stereotypes by favoring the black voters of District 6. Second, you should reverse on racial predominance, because the district court wrongly assumed that our intentional creation of a majority black district in light of the Robinson decisions automatically established racial predominance. And third, you should reverse on the good reasons inquiry, because the district court wrongly, in our view, believed that the Robinson decisions played no role in the strong basis in evidence inquiry. And in the end, I want to emphasize that the larger picture here is important, because in an election year, we faced the prospect of a federal court drawn map that placed in jeopardy the Speaker of the House Majority Leader, and our representative on the Appropriations Committee. And so in light of those facts, we made the politically rational decision. We drew our own map to protect them. This court's breathing room precedents allow that decision. I welcome the court's questions.
So as I understand your argument, we are to accept that the Robinson court required that there be two districts, and that your only interest is in preserving two incumbents in northeast Louisiana.
That's correct, Your Honor. I mean, we have two Article III court decisions that say the VRA likely requires Louisiana to draw a second majority black district. Those were the facts presented to us. In light of those decisions, we said, well, we can't allow the federal court to draw the Robinson illustrative maps because that would have placed Julia Letlow in a majority Democrat district. And so we took matters into our own hands and said, we're going to protect our most high-profile incumbents, draw our own map that ensures that Speaker Johnson and Representative Letlow remain in Congress.
So in order for us to use that line, wouldn't we have to accept that the district court was right, the Robinson court was correct?
Your Honor, I think the way this case has been litigated, the way it comes to the court, the plaintiffs have not put on a pseudo-VRA case to say that the Robinson courts were wrongly decided. I mean, of course, as you know, in the Robinson litigation, we took the position that we should have prevailed. We lost. We lost on those arguments. And at the end of the day, I think in the strict scrutiny analysis that this court's cases set out, the question is, do we have a good reason in relying on what the federal courts told us that the VRA likely required? And I think that's the fundamental error. If you look at pages 53A to 66A of our JS appendix, that's the district court's good reasons analysis. It says not one word about the Robinson decisions. And with all respect to the district court, I think that's not how the good reasons inquiry runs. I mean, I think fundamentally, when you have Article III courts telling you that this is what the VRA likely requires, a rational state is going to run with exactly what the federal court says. We're in the business of complying with federal court decisions. And when they told us that we needed to draw a second majority black district, that's what we did. And I want to go back to the larger context, because I think that's the important factual backdrop here, which is we're in an election year. It's 2024. The Fifth Circuit, if you look at page 601 of its decision, the Fifth Circuit says you have a few weeks to, now that we have affirmed the district court's likelihood of success on the merits finding, you have a few weeks to go back, consider drawing your own map. And it's an election year. We're talking about the Speaker of the House. No rational state gambles with those high-stakes seats in that situation. And our request to this court is to say, well, given that unique circumstance where you have two layers of Article III courts telling a state what the VRA likely requires, that is a good reason for the district, for the state to do what it did.
Well, I mean, do you think the Robinson court was correct?
Your Honor, in our heart of hearts, we've never shied away from our position in the Robinson decisions, which is that we should have prevailed. At the end of that litigation in the preliminary injunction stage, we lost, and so we faced a choice. Do we take a gamble and go to trial, lose at final judgment, endure a court-drawn map, and hope that an appellate court will then step in on the back end of the process and save us from the federal court-drawn map? Or do we say, if the court said what they said, what the VRA likely requires, can we work with that and find a way to save our incumbents on our own? And so, Your Honor, I'm not going to stand here and say that the Robinson courts were right, but I will say that what is set in stone is what they said. That is the law. And we took that as gospel and went back to the drawing board and drew District 6.